Good afternoon, everyone, and welcome to this meeting of the Senate Committee on Education. I'm Senator Angie Taylor, and I have the honor of conducting this meeting this morning. So welcome here in Carson City, and I see a couple of people in Las Vegas. Welcome in Las Vegas, and welcome to anyone who may be on the phone line. We'll start with roll call. Madam Secretary?
Senator Buck. Senator Cruz Crawford. Here. Senator Doniate. Here. Senator Dondero Loop. Here. Senator Rogish. Here. Senator Titus. Here. Chair Taylor.
I am present. Thank you very much. As we get going today, we have two bills, Senate Bill 293 and Senate Bill 368. Just as a starter, you'll go through a little bit of housekeeping. Please silence your electronic devices. Nothing new there. If you plan to testify, please make sure you've signed in and give our secretary a business card if you have one, so we make sure we have you noted. And additionally, if you would like to testify, please make sure that as you sit, you turn on the microphone when you speak and say your name. And spell your last name the first time you give us your name, and then every time you speak, you need to say your name. I know it gets tiring. I know, but we need that so we can have our records and have our minutes be correct. Also, this is a policy committee, so we won't spend a lot of time on the finances because that is taken care of in another committee, but we deal with the policy issues that are here. Let's see, anything else? Yes, also, if you'd like to call in, I knew there was something else. If you'd like to call in to give testimony or to give public comment at the end of the meeting, that number is 888-475-4499. The meeting ID is 897-234-72573. I'll give that number again when it's time for public comment, but I wanted to make sure you had it here. And then finally, you'll see that committee members have laptops and electronic devices in front of us. Please don't take it as a sign of disrespect. We have notes on here, amendments that we just received and so on. And so please don't take it as a sign of disrespect or of inattention. Okay, and now we will begin. We will start at the beginning. We have Senator Lang here. We're going to open the hearing on Senate Bill 293. Senate Bill 293 revises provisions relating to intercollegiate athletics. And you have some friends with you. And I will ask you to introduce them as you will. Senator, please go ahead when you are ready.
Thank you, Chair Taylor. It's so great to be back in education twice in 1 week. I represent Senate District 7 in Las Vegas, and I want to thank you for your time and your consideration of Senate Bill 293, which is going to build on Nevada's requirements for compensation of student athletes for use of their name, image, or likeness in higher education. And before I begin, as many of you know, I was a physical education teacher for many years and a coach. And so Eric and I worked together on an interim study a few years ago about this issue and came up with some recommendations. And so I'm really happy to be here today to talk about this. Before I turn things over to my co-presenters, I would first like to provide background information on recent actions in the legislature has considered relating to student athletes and NIL. In 2021, the legislature passed Assembly Bill 254, which does the following. One, it prohibits certain higher education institutions or the National Collegiate Athletic Association, often referred to as NC2A, from preventing student athletes from receiving compensation for the use of their NIL or from attaining professional services with certain exceptions. Compensating student athletes for those components when it relates to official activities of the institution or of the NC2A. Altering student athlete scholarship awards due to such compensation. And finally, disallowing the student participation in intercollegiate sports for such compensation or use of services. The legislation also prohibits the NC2A from preventing the institution itself from participating in the NC2A for the same reason. Additionally, Assembly Bill 254 authorized student athletes to enter into a contract with an outside entity for compensation, as long as it did not conflict with the contract between the student athlete and the institution in which the athlete is enrolled, and if the student athlete met certain specified responsibilities. And finally, the bill required an interim study concerning collegiate bylaws and state and federal laws related to compensating student athletes for use of their NIL. During the 21-22 interim, I served as vice chair of this interim study. During its 4 meetings, the committee to conduct an interim study concerning the use of name, image, and likeness of student athletes heard issues surrounding NIL policies, including the registration of entities such as collectives and boosters, with state aid to the regulation for NIL deals and student disclosures. 2, challenges specific to junior colleges, such as the lack of financial resources and attention devoted to such institutions in NIL deals, and difficulties with transfer policies for athletes moving between 2- and 4-year colleges and universities. And the correlation between NIL and gaming in Nevada. With that brief history, I'd like to turn it over to, I'm sitting next to two assistant athletic director and athletic director from, one from UNR and one from UNLV. They'll each speak. Then I'll go over the sections of the bill. And we also have an amendment from NICHE that I will go over, and their attorney is on Zoom, I believe, to be able to answer any questions we might have. And then we also have the football coach from UNR that will speak. So do you want to go first?
I think we were going to have him
Okay,
do the.
Eric.
Thank you, Senator Lang. Good afternoon, Chair Taylor and members of the committee. For the record, my name is Eric Nepomuceno, spelled Nepomuceno, and I am the Senior Deputy Athletics Director and Chief Operating Officer for UNLV. First off, I want to thank Senator Lang for sponsoring this needed legislation. SB 293 aims to address the current needs in the collegiate environment as they pertain to the name, image, and likeness space, also known as NIL. Since 2021, 29 states have passed legislation on how student athletes can profit from their name, image, and likeness. As earlier mentioned, in 2022, the state of Nevada passed AB 254, which allowed student athletes to profit from their NIL. This bill recommended for institutions to provide education to student athletes and further required student athletes to disclose their NIL deals to their institutions in order to ensure rule following. The one caveat in this particular bill was that no institutional involvement was permissible with respect to paying the student athletes, as universities were still trying to figure out how to navigate this new landscape. Today, however, the landscape is evolving rapidly. In approximately 2 weeks, on April 7th, 2025, Judge Wilkin of the Ninth Circuit is set to render a settlement decision on the House versus NCAA case. This is a class action antitrust lawsuit which involves a former swimmer challenging the NCAA's rules that prevented college athletes from profiting from their name, image, and likeness. The current settlement for this House case will allow for approximately $2.8 billion in back pay to former student athletes and create a revenue sharing model for current and future athletes, allowing schools to now directly pay student athletes. Correspondingly, with this impending settlement looming, the state legislators have been responding. For example, Alabama has repealed their NIL state law, allowing institutions to adopt their own rules. Other states are currently looking to make the income earned from NIL tax exempt. Ohio has also issued an executive order that prevents student athletes from being classified as employees. There has been an aggressive and intentional push by these states to amend their state laws to best prepare their institutions for the newly anticipated college ecosystem awaiting us around the corner. In order for Nevada not to be left at a competitive disadvantage as states make these changes, SB 293 aims to align Nevada state legislation with the impending NIL case precedent and future settlement requirements by making one change. This bill will more importantly permit institutions to broaden the scope of their involvement and guidance, which will inherently allow for stronger protection and safeguards. This will in turn look to better protect the student athletes against the vulnerability of third-party exploitation. The notion of added NIL protection for the student is imperative, as several student athletes across the nation have already been taken advantage of by unscrupulous agents and unfulfilled deals and promises. Now, to be clear, this bill will not lead to moving public dollars to use for these purposes, but rather to further advance philanthropic efforts within the athletic department for the support of the student athlete's experience. Finally, as mentioned, there is an amendment that we consider friendly, submitted by NSHE, that looks to exempt these student-athlete NIL deals from public records requests to preserve their privacy rights and any proprietary student-athlete information. We have Linda King from NSHE available down south in Las Vegas, ready to answer questions in relation to that amendment. At this time, I would like to turn it over to UNR AD Stephanie Remp. Thank you for listening, and we welcome an opportunity to take questions afterwards.
Madam Chair and members of the committee, thank you for the opportunity to be here. I am Stephanie Remp from the University of Nevada, serving as the athletic director. Really honored to have the opportunity to share a little bit of the big picture of college athletics and the direction that we are headed, as well as hear from our football coach who is dealing with this on a daily basis. So looking back in the history, and Eric outlined it beautifully, NIL became a law in 2021, and it made it permissive for student athletes to generate money off of their name, image, and likeness. We all believe in college athletics that's a very, very positive thing. Student athletes have never been able to do that, and it is based on their own name, image, and likeness. It is not about the institution. And so they are able to start a business, they're able to do social media, their ability to build their brand, and then get compensated upon that if they start a business and they want to use their name. The difficult thing that has happened since then is the collectives that everybody has heard about, where people are giving money into basically a black hole that is used to then pay student athletes. And unfortunately, all the leaders in our industry have been lobbying Congress to try to get some sort of federal guidelines around it to control that. That has not happened. So then the lawsuits have all happened, and we've been faced with lawsuits for many, many years that have changed a lot of things in our industry. Specifically, the House case that is coming forward is changing it's another significant change that will start this summer, where student athletes, what the settlement terms that are agreed upon by the plaintiffs and the defense that is now going to the judge will allow multiple things to happen. One is obviously the back pay, the $2.8 billion that both UNLV and the University of Nevada will both have to pay, in addition to all the other schools in the Power 5 conferences. So that will be back pay. And then going forward, there are 4 different areas that are really being touched. One is they are suggesting that it's probably going to be close to 300 rules in the NCAA manual that will change. In addition, there is a evaluation of the money. And the way they have done that is they took the average revenue from the 68 Power 5 conferences, which is about $100 million per school, and they took 22% of that, and that cap expected next year is $20.4 million that schools will be able to pay up to that to their student athletes. And that is something that will be obviously a competitive issue across the country. There will be a component of how you control that cap. In addition, all of the name, image, and likeness deals that are happening today that are sort of outside of our scope, they're with businesses and companies in most of them in the communities where the schools are. There will be a control on that where everybody has to report their NIL deals, which is a change from today, which is a positive thing. And then the 4th component is enforcement. So they have to figure out how they are going to put teeth into all of these new rules that we are able to control what is happening out there. So with those 4 changes, we are going forward, and both UNLV and the University of Nevada need to be able to compete in that arena, which would be allowing us to be able to pay our student athletes through revenue generated by our departments. And so obviously I'm happy to answer any of those questions, but we thought it would be helpful to have our football coach be able to explain what he is dealing with on a regular basis in this new landscape, and how it is important that we be able to have the opportunity to use revenue share to be able to pay our student athletes. Coach Choate?
Yeah, Madam Chair, members of the committee, I appreciate the opportunity to share my insight on this topic. My name is Jeff Choate. Last name is spelled Choate. I'm the head football coach at the University of Nevada. I've dealt with this, pretty much on a daily basis when you're doing roster management and roster construction in modern college athletics, this is one of the topics that's going to come up. Recruiting never stops. It's a 365-day-a-year activity. And recruiting always used to be 1 + 1 + 1 + 1, meaning proximity, tradition, school colors, uniforms, whatever. Well, the new +1 is this name, image, and likeness, which now is transitioning to rev share. I think that that SB 293 is important, as it was already mentioned, to make sure that both UNLV and the University of Nevada do not become in a situation where we've got a competitive disadvantage over other people that we're recruiting against, but also to protect the student athletes and provide more transparency, because the institution can now be directly involved if we change this law. And so I think that's a really important component. There are a lot of people out there right now that have their hands out for these kids, and it can be very confusing. And they're going to come to us. They're going to come to us for advice. They're going to come to us to gauge what type of NIL deals or what percentage of rev share there might be, and the kind of shipping it down the road and saying, hey, I don't talk about that. Go talk to somebody from the collective that they may not have a relationship with or their parents aren't comfortable with. I think creates problems. And so us being able to be involved in those conversations are important and really vital, like I said, for the protection of the student athlete, but also to make sure that we are kind of doing what is best practices based on the ever-changing landscape of college athletics.
Thank you, Coach. So just, I'm not going to go through the bill because I think you did a fantastic job of outlining kind of what the lay of the land is. But I do want to say, I think our legislature made the right decision a few years ago when we decided not to do an NIL bill and we didn't want to because when NIL came to the forefront, states made laws about NIL, and they found out they were very restrictive and they weren't in the best interest of the schools or the athletes, and then they had to repeal those laws, and a lot was going on, and it was new. So I think we are at the place where we've seen what happens, we know about the court cases, and now I think is a good time for us to pass a law to protect athletes and schools in Nevada. And lastly, I just want to thank Senator Donate. He had this bill, and I said, I just really want to do this bill, and he graciously gave it to me, so I do really appreciate that. And with that, we stand ready for questions. Oh, I was going to tell you about the amendment. She went over the amendment as well, so we're ready to answer questions. And if you have a question about Enchi, the attorney is in Las Vegas. Thank you.
Thank you, Senator Lang, and our athletics directors, and Coach Choate. We appreciate the presentation, and it's been very informative, I know, for many up here. So we will first turn to the committee. Any questions? We'll start with the innovator, the designer, the real reason we're here. Senator Donante, please, you have a question.
Thank you so much, Chair. I just have more of a clarifying question. It's relevant to this bill, but I don't know if the bill touches it. First and foremost, I think we talked privately about this. My former university president, when I went to my master's degree from Maryland, he always said that athletics was the front porch of how we attract students to the university. And if we want to compete with the Michigans and et cetera of the world, then we need to focus athletics to build the brand identity of the students that we're trying to recruit, right? It's the academics and it's the athletics. And so I think any bill, including this one, that helps us get to that is 100% what we should be on board. I'm assuming the issue of, for example, if we wanted to use NIL or an NIL fundraising strategy through, say, a foundation and so forth, the tax-exempt deductions for individuals to contribute, is that more of a federal issue, or is that something that we can control statewide? I think that was kind of mentioned in terms of what other states are looking at, specifically to contributions, and so I don't know if you guys are able to answer it. It's more of a logistical or technical question than it is on the bill.
So I'll give it a shot, and Eric can chime in. So when donors...
Give us your name.
Sorry.
It's okay.
Stephanie Remp, the University of Nevada Athletic Director, for the record. So institutions are 501c3s, and so when if somebody donates to the university, even if it's for the revenue share, that is tax deductible because it's a 501c3. You had talked about what the schools that are looking at different pieces of legislation in their particular state. It is when the university is paying the student athlete, they are trying to get those payments to be tax exempt. Currently, our student athletes and the cash, the scholarship checks they get, those are considered financial aid, and it's not. They are not taxed. When they're getting their NIL deals through the businesses, those are taxed. When we start paying revenue to the student athletes, those will be taxed. But there are states that are trying to keep those from being taxed, which I think would be interesting.
Thank you, Senator Donante. We have Senator Buck.
No worries. Thank you, Chair. Currently, I was just wondering where is all the revenue coming from, and if the athletics program is operating, on the positive. But where is all this revenue coming from, especially to pay the lawsuits? And then secondly, would this have prevented what happened, I think, when the athlete tried to semi-extort the university for more? I realize it was a misunderstanding that it was played out in the press, but how do you prevent the highest bidder from not prevailing? I mean, I can almost... Anyway, that's a couple questions, so that's my limit.
Okay, so I'll answer the first question, and then I'll defer to Eric on the football player situation. So, Stephanie Remp, for the record, athletic director at the University of Nevada. So we are by having this law or this bill changed is not determining what we will pay. It is going to be up to the institutions for how much they can generate, raise, shift around the monies within the department to figure out how much we can pay the student athletes. So we are not anticipating any sort of running in the red or asking for additional funds or anything like that at this point, although we do know different states are passing laws to help compensate the student athletes. For us, we're trying to get it to be permissive, and then it's up to each institution for how we generate revenue to be able to pay them. And so we're working through that. We literally meet on it multiple times a week, talking about how are we going to carve out money in order to be competitive, and how are we going to go raise additional dollars to help pay.
Eric Nepomuceno, for the record. I'll touch on the student-athlete question, and that's a great question. I do believe that if this was in place during that time, there would have been more control measures surrounding that circumstance. From my experience, that was the epitome of he said, she said, and there wasn't anything for us to do to protect the student athlete. And all we knew was what our coaches were telling us. And as a result, that student athlete essentially said that there was an unfulfilled promise. But again, there was nothing to corroborate that unfulfilled promise. So I think what we would be able to do if this bill were to pass was to put our student athletes in a situation where they have things that are written down, where they're provided guidance, and ultimately help manage expectation through our administrative oversight.
Thank you, Senator Bush. Vice Chair Dondarolu.
Thank you very much, Madam Chair. I'll just comment. I think we need to be careful about using words that attack anybody's character because we weren't there and we don't know what happened. I would suggest that, probably what generally happens is that some other adult who may be an agent or somebody else is advising the student. So I think we have to be very, very careful about attacking character. I guess my question is that when we think about these students getting their funds, first of all, I worry because, and I think I've said this before in meetings, because, by the way, we go back to 2019 when this bill was first brought by Speaker Jason Frierson then in 2019, and I chaired that committee, and that's why I remember it very clearly. I think one of the things that I worry about is that students jump from institution to institution. So you have our freshman UNR star freshman of the year athlete who leaves. because he gets a better offer, right? Or whatever it is. You have a star freshman UNLV, it doesn't matter what the institution is, star UNLV athlete who leaves the institution. They go to the next one, then they leave the next one, then they leave the next one. And before they know it, they've been through 4 years or 5 years of college and they don't have a degree, which they set out to get. They may or may not going to be playing football, basketball, I don't care what the sport is again. And I worry about them ending up with nothing. They've got some money in their pocket, but that money's not going to keep them forever. So how do we protect students from that piece? And that's what I think I'm worried about, is that the student being protected from the lure of I'm going to have money, but not really ever achieving their credentials, which is what they set out to do.
Stephanie Remp, for the record. I would love to have Coach Choate talk about that exact situation, because that is what he is dealing with every day.
Yeah, I think, appreciate the opportunity. Jeff Choate, head football coach, University of Nevada, for the record. This is happening on a regular basis. I had a conversation not long ago with a young man who felt very strongly that he wanted to continue his education at the University of Nevada, but was feeling pressure from maybe some nefarious partners and the community, but also he mentioned specifically, hey, I can take care of my family. And so this is, anecdotally, this is something that has not come up in the past. If a young man or young lady wanted to take care of their family financially, the move was leave school early, go to the NFL, the NBA, et cetera. And now there's this expectation that these young people are providing financial assistance to their families through name, image, and likeness. It'll move to rev share at some point in time after April 7th. It's a real concern. And even for me, I had to kind of do some soul searching, because this, I got into public education. I was a high school teacher and coach for 9 years. And I didn't get into college coaching so that we could turn it into professional sports. But what I've decided is that I can still have a huge impact on these young men, even in short time. And maybe some of them are going to choose to stay at the University of Nevada because of the value that's brought to them outside of name, image, and likeness, and the opportunities to see the world in a different light and to get a great education. But I can't impact, what's going to happen in the homes. I don't have control over that. And I've kind of got to let that go. I agree with you. It's frustrating, but candidly, this is the new reality. And I think we've got to embrace it, and we've still got to do what we can to impact these student athletes as much as we can, whether it's one season, whether it's 4 years. Try to stay in touch with them, try to continue to mentor them and guide them, because that's my purpose. And I think if you look at it otherwise, you're going to get really discouraged and frustrated. And so I hope that gives a little bit of insight.
Thank you, Coach, very much for that information. So a follow-up, Madam Chair. Thank you for being a high school teacher, because I know that helps you as you move forward. I was an elementary teacher at the other University of Nevada, just at the other end of the state. So we'll clarify that. You're wearing red. I'm wearing my red, and the chair is wearing her blue. The other question that I have is, are we going to have counselors in place, if you will, not just somebody out there, because the football coach is busy, right? The basketball coach is busy. So who is it that we're going to put into place to counsel these kids and say, hey, no, the money looks good, but let's process, just like we do as parents. So who is going to help these kids think through this process?
Eric Nepomuceno, for the record. Well, right now, NIL has fallen onto the laps of compliance officers across the nation. They work regularly with rules and process. I feel like it would start there at the university level, but I really think to make the impact that you're talking about, Senator, we would really need to specialize this NIL advisory committee institution to institution, right? Because every model is different. So you would have to figure out what the needs are at your particular institution, and then based on that, figure out who the best best advocate for your student athletes would be. It may necessitate having a compliance officer take on a new role, and right now it currently lives there. But I do agree that there will need to be some sort of expertise. What we don't know, again, just based on the settlement, is what the actual particulars will be. And once those come out, like all the other rules that we've had an opportunity to read and to apply, we'll be able to best assess the need of the actual individual to help our student athletes.
Thank you. And then just one last question. When you talk about this settlement, what I'm hearing, and I have not read it, so I don't know. I'm hearing you say when this settlement is agreed, blah, blah, blah. Is that because this settlement has already been reached? It's just the amount of money that is going to be decided upon, or has the settlement actually not been reached yet?
So the terms of the settlement. Stephanie Remp, the athletic director at the University of Nevada, for the record.
Reno.
So I heard you felt that way. The settlement terms between the plaintiffs and the defense have been agreed to. Now it's the judge that is ruling on whether that she accepts those settlement terms. And it's been back and forth for several months now. And I think we're all anticipating, and actually April 7th is the date of the national championship game for men's basketball. And it's also the date of Judge Wilkins' ruling, which I think will be fascinating for our entire industry. However, I think there's also a chance that it might not be what we're all expecting and something could get pushed off or whatever. But that right now is where we are.
I appreciate that clarification. Thank you very much.
Thank you, Vice Chair. Senator Titus?
Thank you, Chair. Good to see you guys again. Thank you for being here and looking out not only to protect our institutions, but most importantly to protect the athletes. I have a couple questions, if I might, Madam Chair. First, what assurances can you give me that the money that you generate, the University of Nevada generates from the NIL agreement, won't be used to shore up your budgets if you have a deficit?
Stephanie Remp, for the record. So for us, when it comes to donations from donors, I don't want to go as far as saying it's illegal, but if the donors specify exactly where the money is expected to go, it is incumbent on us to ensure that that happens. And
What if they don't say where they want the money to go?
so right now, if somebody donates to the university, it goes, if it's a general donation, it goes to the PAC Excellence Fund, which is our kind of all-encompassing donation pot, and then we use that to distribute out in terms of what we need for operations, what we need for salaries, all of the different things that make up our budget.
So I'm hearing you could distribute if it's not specified to making up your budget.
So, and I want to make sure I'm answering it correctly.
So my question is, if the funds come in through the NIL program, and you have a deficit, so you have a pot of money that donors are donating to this, whether it's marketing, whatever, they donate. Now you have this pot of money that's in the university system. What mandates that it actually goes back out to the student athletes versus being used for your budgets where you have a deficit?
So for us, when we receive donation, Stephanie Remp, even back and forth, Stephanie Remp, for the record. When donations come in, we have several foundation accounts. So if they are donating to a particular capital project, it goes in there. If they're donating to a particular sport, it goes in there. If they're donating to name, image, and likeness or revenue sharing, it would go in that foundation account. The foundation on our campus will not transfer that money anywhere other than where it is designated when it goes to that account.
So the answer, I think what I'm needing to hear from you is that the money donated into an NIL account will not be used for anything other than the student athlete.
100%.
Okay. A follow-up question on that? All right. So I'm looking at the actual bill and looking at the proposed amendment, Section 2, Number 4. That was the NCHE's proposed amendment. So I think you mentioned, Director, that early on about, we've talked about 501c3s and nonprofits and taxes and those kind of things. And that this particular paragraph says that it's going to be kept private and not disclosed, whatever the agreement is for the student athlete. My concern with that, and I need some clarification, this is a direct income to the student athlete. Are they not paying taxes on this? Will they not be filing income tax? I mean, there has to be some public accountability for these funds. Can you clarify that for me?
If I may, just because it was Inchi's amendment, shall we have them come forward and talk about why they thought it was important to bring this amendment? Is there anyone here? Oh yeah, we have the attorney. If you wouldn't mind jumping on, of course, introduce yourself, and then let's find out why Inchi thought it was important.
Thank you. Good afternoon. For the record, Linda, Lynda King, King, Senior Associate General Counsel for the Nevada System of Higher Education. I'd first like to just dispel any perception that there's really a difference between NSHE and the institutions. But for the institutions, a system would not exist. This amendment was drafted, considered in collaboration with both the University of Nevada, Reno and the University of Nevada, Las Vegas. The purpose for the amendment is to keep in line with the same thing that the athletic directors have explained to you today, which is in the interest and protections of our student athletes. The amendment is intended to exempt these NIL contracts that are in the custody and control of the institutions from the Public Records Act. It would not extend to any individual student athlete's obligations to report for tax purposes.
Thank you for that. So this money is going to have to be declared somewhere. I mean, and he or she will pay taxes on it. It's not going to be money that nobody ever knows how much you're making. They're going to have to be accountable for it somewhere.
There's a couple pieces. Obviously, Stephanie Remp, for the record. There are a couple different pieces. One, obviously internal, and we have to manage our salary cap, but there is an external group where every institution has to disclose the salary cap numbers for every student athlete that is receiving revenue share, as well as NIL, both.
Just follow up on that comment. So, great. So, universities will have a salary cap then, and so there has to be some public. So you can't just be giving these men or women money, and then at some point, it's somewhere there has to be a maximum that university can receive, or it has to be public. That type of information will be public.
Stephanie Remp, for the record, in terms of individual students' name and how much, I don't think we have clarity on that, but X athlete and this amount of money will be documented and submitted to the outside group. So
And
that
the outside
they know.
group is?
So it's Deloitte is the company that has been hired by the NCAA to manage all of the numbers for every school.
So you know my feelings about student athletes, as opposed to now these are all professional athletes in my mind, because they're getting paid. So, but somebody's going to monitor and mandate that. Is it based on the university system that you can only have a salary cap? Because I'm very concerned about the whole process of paying student athletes, and wondering where's the accountability. What we make is public, and it's just I'm very concerned that you've used the term somebody said dark money, and some of this stuff that happens. I'm worried about that there has to be some accountability of how much is going in, who's paying, and again, in a betting state, lots of things can go wrong here, and I just worry about accountability and really concerned about.
So Stephanie Remp, for the record, I think there's a lot of different pieces to that. One, just clarifying. So we have about 450 student athletes. There's less than 100 at the University of Nevada that are receiving NIL deals. So there are 350 other student athletes that are competing for the love of the game and their scholarship and all that. I think that's important to recognize. A lot of this stuff has been created because of the lawsuits that are impacting a much fewer number of the 500,000 student athletes that are competing across the country. So we today have all kinds of requirements from the NCAA. So the fiscal reports that are due January 15th every year, we have to report all of our revenue and expenses. We have an EADA, it's Equity in Athletics Disclosure Act, that goes through all of the expenses and the participants that we have on men and women, scholarships, all of those types of things are reported. They are creating systems for this as well. And so we know this is going to be very public, but for us, the concern is not sharing the specifics of an athlete and how much because of the recruiting impacts that will have. And that's a concern. But it's not that we will all know because we are the ones that are going to be paying them as a department. But I think when the media requests lists of your student athletes and how much they're receiving, that's what we are trying to protect. Eric, I don't know if you want to.
No, I'm good. I think that's fine. I think I've gotten my questions, and thank you. Thank you very much.
Thank you, Senator Titus. I do have a couple of questions, and thank you so much for your indulgence as we ask these questions. Where did I write my questions? I wrote them down. Okay, here we are. This is for Coach Choate. I believe you're still there. Can you talk a little bit about just how the NIL has impacted your team's competitiveness?
Yeah, I thank you, Madam Chair. Jeff Choate, head football coach, University of Nevada. I appreciate the question. I've seen this from both sides. I was at the University of Texas prior to taking the head coaching job at Nevada, and our salary cap, and maybe let me just explain really quick. The term salary cap is obviously a professional term, but we're not referring to a specific dollar amount. Each institution, each sport is going to have a maximum amount of dollars that they have available to them on a year in and year out basis. Okay, so I'll give you an example. When I got to the University of Nevada, I was coming from the University of Texas. Our salary cap at the University of Texas for NIL was about $18 million in 2023. We made it to the college football semifinals. At the University of Nevada, I think I'm not the head coach at the University of Nevada because the program was crushing it. There's been some struggles recently in the football program, and a big part of my job and my role and responsibility is to right the ship, and I plan on doing that. And so when I got to the University of Nevada, I had available to me in name, image, and likeness dollars through a third-party collective $125,000. So that shows you the competitive distortion between a Power 5 program like Texas that has almost unlimited resources and a place where there's some struggles, right? So there is a direct correlation to being competitive and investing in a program, whether that's facilities, whether that's coaches' salaries, and now obviously with revenue share and name, image, and likeness. And so hopefully that paints a good picture in terms of the competitive imbalance between some Power 5 programs and some Group of 5 programs like Nevada. I could give you some anecdotal examples of what's going on within the Mountain West, but I think one of the powerful things that's going to come out of the House settlement is that we're going to have a little bit better idea what sandbox we're playing in. We'll have a little bit more information about what Colorado State is spending on rev share, what UNLV is spending on rev share. Right now, those are all kind of whispers in the dark, if you will.
Thank you, Coach. I appreciate that. I just wanted to have an understanding of NIL, and revenue share is going to be similar and how it impacts the programs, because this is about the programs in our state remaining competitive. One thing I would say, and I want to make sure that I'm not missing this, and certainly for the committee, is that student athletes, this isn't saying let's have permission to pay student athletes. Student athletes are already getting paid. This is saying let the universities, let the institutions be involved in that, which should provide a greater level of safety and security for our athletes. Am I getting this right? This doesn't create, now let's pay. We're already paying.
Stephanie Rep.
Now we are already paying. The athletes are already being paid for those who can earn that. This just says institutions can be a part of that.
Stephanie Remp, for the record, yes.
Thank you. I love that answer. Yeah, I mean, just it's short.
It is, I think, I'll just add, Eric Nepomuceno for the record. There are already buckets that you have mentioned that the student athlete is allowed to get paid. Scholarship, for example, stipend. Alston was another case that passed recently. This just allows NIL to be added to that bucket.
Okay, thank you so much. I do have just a couple of other questions. Will you just clarify a little bit? What if this doesn't pass? Can we talk a little bit? Not we can. Will you? I guess each institution talk about what kind of impact it can have on your competitiveness and our student athletes.
Stephanie Remp, for the record, it would be. I don't want to overstate, but it would put us at a very significant disadvantage at our two institutions, because we know across the country every school. I shouldn't say every school because I don't know it for sure every state, but every school is planning to be able to pay rev share. And if we are not able to do that, then it still keeps it off the books, and it just makes it a lot more difficult.
Eric Nepomuceno, for the record, I would echo those sentiments. I would also suggest that it doesn't allow for us to protect the student athletes in the manner in which we want to. Again, we've already seen athletes being taken advantage of, bad actors such as agents, and bad deals. Again, this allows for us to have a little bit of oversight. If it doesn't pass, I humbly believe that we would not be in a position for athletic success based on what our competitors would be doing.
Thank you to the athletics directors. Are there any other questions from the members? Okay, yes, Senator Donante.
Thank you, Chair. I just want to make a quick statement that long term, outside of this bill, I think we have to start thinking innovatively of how we can capture more revenue to go towards athletics. I think it's a shame that we saw two coaches, both from institutions, leave to other institutions because they got offered to get paid more, when very clearly we were performing really well and we should have done our best as a state to keep them. And so that's a more of a 2027 conversation, and I think we could all work towards improving that. So I just wanted to say that.
Thank you, Senator Donante. Other questions from the members? Okay, seeing none, Senator Lang and our athletics directors, if you wouldn't mind stepping back, and yes, and then you'll have an opportunity for closing comments after. But now we're still in our hearing for Senate Bill 293, and we will open it up now for anybody who would like to testify in support of Senate Bill 293 here in Carson City, or if you're in Las Vegas, please come forward if you're there to testify in support of Senate Bill 293. And it doesn't look like we need to limit time, so you'll have 2 minutes.
Good afternoon, Madam Chair, committee members. Todd Inglesby, representing the professional firefighters in Nevada. As a union organization, I think it's important that our student athletes here in Nevada get the protections they need. Also, I think it's vital that the playing field's established for the universities, so therefore it eliminates the confusions. Our student athletes come here. The success of our student athletes and our organizations bring more people to the universities here, and hopefully they can help fill some of the shortages that we have in doctors and nursing and all our industries. So I think it's important, and we need to remember that. I also think it's important that a lot of stuff is being talked about student athletes getting paid. That's already established, and Madam Chair, you hit that right on the head. So now we need to make sure that we're competitive. We're bringing industries and folks here in our community that will stay here, but also will bring recognition from all over the country and other industries to follow. Thank you.
Thank you so much, Mr. Inglesby. Please go ahead.
Thank you. Good afternoon, Madam Chair, members of the committee. For the record, Alejandro Rodriguez, Nevada System of Higher Education. SB 293 represents an important step forward in ensuring that Nevada students, athletes have the same opportunities as their peers across the country in this evolving landscape of NIL rights. So we'd like to thank Senator Lang for her leadership on this issue, and we urge your support. Thank you.
Thank you, Mr. Rodriguez. Seeing no one else here in Carson City and no one coming forward in Las Vegas, AVH, do we have anyone on the phone lines calling in to support Senate Bill 293?
Thank you, Chair Taylor. The public line is open and working. There are no callers at this time.
Thank you so much. And now we will open up for anyone who would like to testify in opposition to Senate Bill 293 here in Carson City. Come forward, or there in Las Vegas. If there's any opposition testimony, come forward at this time. Okay, seeing none, then AVH will go to the phone lines.
Thank you, Chair. The public line is open and working, and there are still no callers.
Thank you so much, AVH. And now neutral testimony. We'll open it up for anyone who would like to testify neutral here in Carson City or in Las Vegas. Seeing none, AVH, one more time. Anyone sneak in a phone call just that fast?
Thank you, Chair. We have no callers at this time.
Thank you so much, AVH. We'll ask our bill sponsor, Senator Lang, would you like to have any closing comments?
Thank you, Roberta Lang, for the record. I just want to make a couple comments. I want to first thank our presenters, co-presenters. It was great that they could take time away and be here for this important subject matter. I ask you to support this bill to protect our athletes and to help our schools get some guardrails on what's going on. This is happening across the country. I want us to remain competitive with other schools across the country. If you'll remember right, a few years ago when we were dealing with this, I know Senator Dondero Loop will remember, the NCAA, I'm thinking NIL, NC2A didn't want to make rules. They wanted all the schools to make their own rules. And finally, we're getting to where we can come together and level the playing field. And I urge you to support this bill.
Thank you, Senator Lang. And again, thank you to all the presenters and co-presenters and those who jumped in on Zoom. We appreciate it. We will now close the hearing for Senate Bill 293 and go on to our next bill. Now we're going to open the hearing for Senate Bill 368. I thought that was over 368, and Senator Rogich, our colleague from our Education Committee, please go on down. And Senator Rogich, you may begin when you're ready, and you know this, you'll have 15 minutes for the presentation.
Good morning, Madam Chair, or good afternoon, Madam Chair, and members of the committee. Boy, the hours are flying by today. Thank you for the opportunity to speak today in support of this critical legislation to codify the Individuals with Disabilities Education Act, also known as IDEA, into state law. All of us are witnessing unprecedented events on a federal level. This bill is not only a safeguard for the rights of students with disabilities, but also a testament to our state's commitment to protecting our most vulnerable children. Along with Marina Dahlia Hunt, Jonathan Norman, and one of my favorite people, Barbara Buckley, as well as the many committed advocates at the Legal Aid Center of Southern Nevada and throughout our state, we have worked tirelessly throughout the years to be a voice for the thousands of children with special needs in our state. And so it is my pleasure to work with and co-present with Marina Dahlia Hunt in Las Vegas. She is the team chief of the Education Advocacy Project at the Legal Aid Center. I would also like to mention that an amendment has been submitted. However, the language is a work in progress and will most likely change as we continue to meet with stakeholders and as events unfold or continue to unfold. Just a little bit about the IDEA for some of the folks that are unfamiliar with it. This act was enacted in 1975 and has been a cornerstone of educational rights for students with disabilities. It ensures that every child, regardless of ability, has access to a free, appropriate public education, also known as FAPE. It's tailored to their unique needs. IDEA has transformed the educational landscape, providing critical protections such as individualized education programs, also known as IEPs, procedural safeguards, least restrictive environment. These protections have empowered millions of students to achieve their potential, contribute to their communities, and lead fulfilling lives. Despite its success, IDEA's future at the federal level is not guaranteed. Legislative or administrative changes or executive orders could weaken or repeal its provisions, leaving students with disabilities vulnerable to losing their rights and access to necessary services. Without federal protections, states would be left to fill the void, and the absence of a uniform standard could lead to significant disparities in educational opportunities. So by codifying the IDEA into Nevada law, we can ensure that the rights and protections it provides remain intact regardless of federal action. And so this legislation would protect educational rights, provide stability, demonstrate leadership. So education is a fundamental right, and it is our moral and legal obligation to ensure that all children, including those with disabilities, have access to quality education. Codifying the IDEA into our state law is not just a policy decision. It is a statement of our values as a society. It affirms that we believe in the potential of every child and that we are committed to providing the resources and opportunities they need to thrive. Some may raise concerns about the cost of implementing this legislation. However, the long-term benefits far outweigh the initial investment. Students with disabilities who receive appropriate education and support are more likely to graduate, pursue higher education, gain employment, and contribute to our economy. And so at this moment, I'll pass on to Marina, who is in Las Vegas. Thank you.
Hi, good afternoon. Marina Dahlia Hunt for the record, Marina Dalia-Hunt. As Senator Rogich mentioned, I am the team chief for the Education Advocacy Program at Legal Aid Center of Southern Nevada. Within our program, we represent the educational decision makers of children in foster care, as well as parents and guardians in the community struggling with special education related issues. Everything we do to help these children is because of the IDEA. The IDEA enshrines a decades-long fight for the rights of students with disabilities to access an education. The key principle of the IDEA is that all children, regardless of disability, must receive a free, appropriate public education, or a FAPE, in the least restrictive environment. This means that schools must provide the necessary support and services to enable students to succeed academically and socially. The IDEA is foundational and has a broad scope. I would like to highlight a couple of key provisions that are not currently addressed in Nevada law that this would fill the gaps in for were the IDEA repealed at a federal level. First, all public schools must conduct appropriate evaluations of students suspected of having a disability at no cost to the parent. And then if the student does have a disability, must craft an appropriate IEP, individualized education plan, that serves as a legally binding document outlining the educational services, accommodations, and goals for the child, which is collaboratively developed through a team of parents and school professionals. The IDEA requires that children with disabilities be educated in the least restrictive environment possible, meaning that to the extent possible, children should be educated alongside their disabled peers. The IDEA provides families with specific due process protections and rights to resolve disputes with school districts, including the right to an impartial hearing for substantive and procedural violations of the IDEA. It also calls for full parental participation in the decision-making of their children at all meetings related to their child's education. The IDEA covers early intervention services for infants and toddlers, as well as transition services for older students to help them prepare for life after school, and sets forward protections for children with disabilities in the context of disciplinary proceedings to ensure that children aren't excluded from school due to manifestations of their disabilities. The IDEA is more than just a law that protects the rights of young people with disabilities. It is a statement of our social goal that children with disabilities receive a quality education tailored to their unique needs. Before the IDEA, children with disabilities were often marginalized, institutionalized, or simply not educated at all. The IDEA addresses this disparity by mandating equal access to education and resources and opportunities. The IDEA also empowers parents to be active participants in their child's education. Through the IEP process delineated in the IDEA, parents have a legal right to be involved in the decision-making process for their child, adding an important voice and advocate for the student's needs and experiences. The law also ensures that the unique needs of students with disabilities are met as they prepare for higher education, employment, and independent living. SB 368 is a trigger law that would only take effect if the federal government repeals the IDEA. The reason we need to do this is if the federal IDEA were to disappear, thousands of children with disabilities across Nevada would have the rug pulled out from under them. Passing this law would minimize the harm to students while dealing with the uncertainty that would stem from a repeal in whole or in part of the IDEA. A national repeal of the IDEA would cause an educational crisis, but passing this law in Nevada would mean that we could navigate this crisis appropriately in real time while making sure children with disabilities are not stripped of their rights overnight. Thank you very much for your time.
Thank you, Ms. Dahlia Hunt. You have more, Senator?
No,
No.
we're available for
Oh,
questions.
sorry.
Thank you.
Okay, thank you so much for the presentation, and thank you for joining us from Las Vegas. Senator, we'll see if any members have questions. We'll start with Senator.
Thank you, Chair. So I thank you for the opportunity to ask a question. Thank you, Senator Rogich, for looking out for the most vulnerable. My question really is, it's been my impression from things that I've heard from our president that he has no intention of touching this. What has given you the thoughts that you needed to bring this forward, as there's been no indication that this would happen on the federal level?
Chair, to Senator Titus.
No, please go there.
Marina, would you like to answer that question?
Sure. Marina Dahlia Hunt for the record. There currently is a lot of uncertainty. So as I first mentioned, this is a trigger bill. So it would not impose any additional obligations on Nevada unless and until the IDEA is substantially limited through potentially executive order or through repeal at the federal legislative level. What we do know currently is that one of the stated goals is to abolish the Department of Education, which has, and the IDEA and the implications on the IDEA really haven't been addressed at this point. This is a protective measure to ensure that if that does become a concern or a target, that children with disabilities in Nevada don't have those rights stripped away from them.
And so I'd like to add to that, please, Chair, to Senator Titus.
Name?
Lori Rogish, for the record. Recently, we were advised, and there is a group called the Council of Parents, Attorneys, and Advocates, in which they follow very closely what is occurring with on the federal level and the events that are unfolding. And one of the things that came out, and I know this is a policy committee, and I'm not going to get too far into the fiscal component of it, but last Friday, a continuing resolution was signed into law, and missing from the resolution were the spending details known as line item spending for the budget's largest federally funded programs, including the IDEA. So missing in that detailed line items is regarding the funding for Part B, Part C, and Part D. And Part D includes, I gotta find my little notes, includes a focus on support for special education personnel, preparation, training, special education outreach, research to practice initiatives to support making classrooms, books, materials, technology accessible, inclusive of accessing education programs through IDEA and Section 504 of the Rehabilitation Act. So there's an unknown and uncertainty. And again, it's one in which there's that option to put in place any whole or part of the IDEA that is being repealed or dismantled or whatever the term may be. It's just a safeguard for these kids.
And I appreciate you and certainly your passion. Madam Chair, may I have a follow-up question? I think this might be, I'm just looking at a kind of a technical aspect and a procedural aspect, and I may need to have our researcher or our attorney look at this on a process stuff, because this is a bill, protection bill. If things happen over here, then this will trigger that. Do we do the things like this? Because I see that on the bill, original bill, that becomes effective July 1st, but then on the amendment, it becomes upon passage. But again, I just want to, how does that work, and how does it trigger, and who's going to follow it through on a process thing? If this only happens if the federal government does this, and how soon do we have to then move on that action? I'm just curious about a process. So just to clarify again, can I ask you want me to ask you again?
No, please, go right ahead.
Cameron Newton, Committee Counsel. I was going to ask Senator if you could clarify a little bit on the process element that you're referring to, as in who would be taking care of this, or what would be going on.
Yeah, I think we do. I just
These
needed,
senators, I wasn't sure which one.
So I think he's talking to you, Senator Titus.
Right. So I'm curious that this is the triggering thing. This is a triggering bill that if the federal government, in my mind, the Individuals with Disability Education Act, you're concerned that it may be removed via executive order, which I don't think it can be based on how it was started. Having said that, if it was, in any manner, this bill then would trigger that the Nevada would then be responsible for what the federal government is doing. That's the gist of this bill. Is that correct, Senator Rogich? Is that what you're asking us to do?
That is correct. Lori Rogish, for the record, that is correct. And I do believe Congress has to be involved if they're going to.
Right, that's why this can't be removed by, executive orders cannot do this, Congress has to do it. So let's say they do it, then I just need like a procedure thing. Then the way this bill is written, that if Congress does do this, then it would automatically trigger that it would be the responsibility of the state of Nevada to assume what the federal government has been doing.
Cameron Newton, Committee Counsel. Yes, the way that the bill is written here is that these provisions of the IDEA that currently the state of Nevada is already required to follow based on the federal law, if they were repealed, then this would essentially say that those provisions become part of NRS and they continue to apply in this state since they've been repealed.
And then for clarity again on the timing of it, because again, you changed the effective date. So the moment that would be repealed, it would automatically, if the bill is passed, trigger that we would assume that regardless of what the cost, regardless of any of those things. We would automatically assume that responsibility?
Cameron Newton, Committee Counsel. So I can address both elements of this. As the way that the bill is currently written, it says that if it is repealed, then the provisions of the IDEA as they existed on July 1st, 2025 apply in this state. So if the amendment proposed by the senator, which does change this to becoming effective upon passage and approval, instead comes into place, then we would presumably need to tailor the language of what the provisions of the IDEA as they existed on that certain date. So we might have to change that in the drafting process to address, the provisions of the IDEA as they existed upon passage and approval of this legislation, or something to that effect. But that is something that would have to be worked out in the amendment drafting process.
Great, thank you. I just needed some clarity. Thank you.
Thank you, Senator Titus. Vice Chair Dondero-Loop.
Thank you, Madam Chair. So do we know what the current amount of funding is that's coming into Nevada?
Lori Rogish, for the record. I do not.
Okay.
I would need to.
And then
Somebody
sorry.
gives me that answer.
Sorry, Marina Dahlia Hunt for the record. Oh, sorry, can you hear me? I don't know the exact amount, but I do know that it is about 16% of the education budget in Nevada.
Okay, thank you. Because we do know, and I agree with my colleague that the president cannot do this all on his own, but he is in the process of dismantling the Department of Education, which is part of the executive branch. So we also know that we have a Secretary of Education who did not know what IDEA was. So with those things being involved, if they, when we talk about including federal block grants, and those under Nevada, in your amendment, it says under Nevada law, any funds received to fund special education, including those received as federal block grants, do we know if those federal block grants can be stopped without Congress?
I would have to get back to, Lori Rogish, for the record. Chair, if I may speak directly. I would have to get back to you on that. My understanding with block grants, it would be a certain amount delegated towards special education that can only be used for the purpose of providing special education. And so we can set the parameters around the use of those funds if we want, on a line budget, a line item basis. But again, I think things are so fluid, and these are conversations that have come up so very quickly, and we didn't really anticipate this happening as quickly as it is. And so we are open to continuing the dialogue and trying to figure out what language works best in the event things continue to be dismantled and funding gets affected.
Thank you very much. I agree with you that it's happened very quickly and to our most vulnerable students. My concern, the reason I ask about the federal block grants is because we do know that a lot of money comes into our special education and frankly to all of education through grants. And if those can't be accessed, even if they didn't dismantle part of it, we would lose some of those. So we do know that. So that's why I ask that. So I know that we can get some of the answers to some of this offline. I appreciate you bringing this to light, and I may have further questions, Madam Chair, but thank you.
Thank you, Madam Vice Chair. Senator Cruz Crawford.
Thank you, Chair. Senator Cruz Crawford, for the record, I did want to, oh, sorry. I keep thinking I'm a regent. I did want to share that we get for special ed funding approximately $104.5 million a year. The majority of that goes to grants to states. It's about $97 million, and a smaller amount for preschool funds and grants for families. And I appreciate you bringing this piece of legislation as a school principal of a school that has medically fragile students. I have 2 autism units. I have 2 preschool units. I have an intermediate resource. I have a primary resource, and I have a STAR classroom. And so when we talk about the dismantling of education, and the argument is great, states will have more autonomy, I want to make sure that the budgets aren't going to be balanced on our states' backs, and that either we do get that money back to the state, or we see a great reduction in our federal taxes, because as of now, we're already pinched very closely. So I appreciate your advocacy in this area. Thank you.
Thank you, Senator. You want to respond? Go ahead.
Thank you, Senator. I didn't realize you had that many programs.
Name?
Oh, Lori Rogish, for the record.
I know.
I did not know that you had that many programs at your school. Thank you. You're doing a great job and changing a lot of kids and their families. Thank you.
Thank you, Senator. We do have someone here. We have a Julie Bowers here from NDE who can answer some of the questions about block grants and so on. So would you mind if I pull you up? You have a laptop open. That's fantastic. Just stay right there, Senator. She can just sit right beside you. Thank you so much.
Do you want me to go back to the original question? Sorry, Julie Bowers, Director of the Office of Inclusive Education, for the record.
Yes, if you would,
how much
please.
funding we get?
Yes, if you would, please. Thank you.
So as Senator Cruz Crawford mentioned, we average about $100 million a year for allocations to the schools. There's an amount that is calculated according to the federal government that is called administrative costs, which pays for our positions at NDE, as well as a little bit of what they call set aside for discretionary projects at the discretion of the department based on the needs of the schools.
Thank you so much, Ms. Bowers. Any questions for Ms. Bowers since she's in here? Please go right ahead, Senator.
Thank you, Madam Chair. Thanks for coming to the table. So you said currently the Nevada Department of Education receives $100 million approximately in block grants from the federal government. Or does that go to the Department of Health here, or does it go directly to the NDE?
Goes directly to the NDE, Julie Bowers for the record, sorry. And we calculate an allocation formula based on the federal guidelines of how much each district gets of those funds, and we allocate those funds out through a Part B grant. And then we keep, again, that extra little amount that pays for our administrative costs and our discretionary.
Thank you for that follow-up. So then you allocate it based on the number of students that have IEPs, the number of students. How do you distribute that? What's it based on? That yeah. How do you allocate it afterwards?
So, Julie Bowers for the record, allocations of Part B funds are done, we have, and I have this all on record if you want the forms. We have a state set aside, which we take off first, which is that amount. Then there's subgrants to the LEAs. They have a base payment.
Define LEAs for.
Local education agencies. They have a base payment that's based on the number of students that they have with disabilities based on the total number of the state. Then there is a 15% that's allocated based, the remaining funds are then allocated based on 15% of the number of children living in poverty, and 85% is allocated based on public and private school enrollment.
You good, Senator Tice?
So it's not all based on the number of students with disabilities. It's actually based on a number of other facts too. That 100 million isn't just going to students with disabilities. It's spread out through, you said 80% goes to folks in poverty, based on
It all goes to students with disabilities.
Okay.
And then there's an extra 15.
Name, please, Ms. Bowers. I'm so sorry.
Julie Bowers for the record.
Try to get you before you get too far in. Thank you.
That's okay. So there's a base payment that goes out that's based on an allocation formula from the feds. There's a portion of that, our total allotment, that isn't used. So then the remaining funds, whatever that amount is, 85% of that amount goes to public and private school enrollment. So that's really the first chunk of allocations, the base. And then the 15% that's left goes to the number of children living in poverty. So it takes into effect an additional kind of weight, I guess, if you want to say that, to each district. It's a little complicated. So we call it running through the sausage maker. We put the numbers in and it spits it out for us. What I will say is that Nevada, unlike other grants that are based on numbers of students, our allocation from the federal government is based on a census from 1997, and it has not changed. And we are one of the lowest funded states in terms of IDEA. So the amount that we get does not change with the number of students that we have. And so we have to take that allocated amount and do some different allocations based on the number of students that are in Nevada, but the allocation isn't based on the number of students in Nevada.
Thank you, Madam Chair.
Thank you, Senator Titus. You wanted to respond, Senator Rogish? Mm-hmm.
Why the 1997 census?
On
Lori
the record.
Rogish for the record.
Yes.
I'm so sorry. Is that something that can be updated?
Julie Bowers for the record, that would not be updated unless.
Is your mic on, Ms. Bowers?
That is the federal allocation that's in IDEA, and that would not be updated unless they updated IDEA.
Thank you. Any other questions, committee members? Okay, seeing none. Ms. Flowers, thank you. Thank you so much for being ready on the spot and answering some questions. We really appreciate that. And Senator, at this point, we'll ask you to step back, if you would, and we'll open it up for testimony in support. Anyone who would like to testify in support of Senate Bill 368 here in Carson City, or if there's anyone there in Las Vegas, the two of you, would you mind stepping back so we can? Thank you so much. Is there anyone here in Carson City who would like to testify in support? Please come forward at this time, Senate Bill 368. Okay, seeing none. In Las Vegas. In Las Vegas, if you'd like to testify in support, then please go ahead, state your name for the record. You'll have 2 minutes.
Thank you. For the record, my name is Marie Nices, Marieneisess, and I'm the president of the Clark County Education Association. CCEA is the largest educator union in Nevada. I'm here to speak in strong support of SB 368. While we continue to navigate the constant changes coming from Washington, D.C., we must prioritize the protection of our most vulnerable students. Public education is under siege, and it is essential that we ensure every child receives the best education possible. At the heart of these challenges is the need to safeguard the services provided to our special education students. Currently, we face significant struggles in ensuring that every classroom has the resources necessary to provide a quality education, with special education classrooms being especially impacted. Additionally, the shortage of qualified licensed educators, particularly in special education, is contributing to the gaps in the education our special needs students are receiving. We must take immediate action to address any budget deficits that may arise from the potential closure of the Department of Education, ensuring that our most vulnerable students continue to receive reliable and consistent services. I urge you to vote yes on SB 368. Thank you for your time and consideration.
Thank you, Ms. Nices. Is there anyone else there in Las Vegas? Yes, please go ahead. State your name for the record.
Yes, good afternoon, Chair Taylor and members of this committee. For the record, my name is Dr. Brenda Pearson, and I'm representing CCEA, testifying in support of Senate Bill 3868. I would like to call to your attention three components of this bill. The first is the incorporation of a literacy screener to be used in elementary grades. The current identification process for students with learning challenges is that a student must show a lack of academic progress to be able to be assessed for special education. As a teacher, I was told to let students fall 1 to 2 years behind to demonstrate a need to be assessed. 368 offers a proactive path instead of one that is reactive, aligning resources and instruction before a student falls significantly behind in their academics. Second, this bill proactively supports students whose behavior is a barrier to learning. Last school year, special education students were involved in 31% of violent incidences on CCSD campuses, although they only represent 14% of the student population. Students with problematic behaviors need structured and individualized support through plans that incorporate proactive and long-term strategies to correct their behaviors. Last, this committee has heard about the impact a high-quality teacher has on a child's academic success. At the start of the school year, 300 special education classrooms did not have a fully licensed teacher. Additionally, numerous educators are licensed to teach special education and have chosen a general education classroom due to the difficulties they experienced in special education. This bill places requirements on the maximum number of students who can be in a special education classroom and ensures students receive targeted interventions aligned with their eligibility. These changes will have a direct and immediate impact on our students. CCA is in full support of Senate Bill 368 and the conceptual amendments presented to you today. We urge your support on this bill.
Thank you, Dr. Pearson. Is there anyone else in Las Vegas? We'll go to the phone lines. AVH, is there anyone on the phone to testify in support of Senate Bill 368?
Thank you, Chair. To testify in support of Senate Bill 368, please press star 9 now to take your place in the queue.
Good morning, Madam. Good afternoon, Madam Chair. I did the same thing as the presenter. Stephen Cohen for the record, Stephen with a V. Cohen as I'm the now former Assemblywoman. Take the easy way out, follow your instructions, ditto. Thank you, I yield.
Thank you, Mr. Cohen. We have a late arriver here. We'll allow, because we didn't use up all the time. Please go right ahead, state your name for the record for support.
Chair, members of the committee, Jonathan Norman with the Nevada Coalition of Legal Service Providers, NORMAN. I appreciate the grace to be allowed to come in late and testify. Obviously, the IDEA sets a baseline of rights for our special ed kids, and having it incorporated into Nevada law ensures that we're taking care of our own regardless of what happens outside of the borders of the state. So I appreciate the bill sponsor, and I appreciate the committee hearing the bill. Thank you so much.
Thank you, Mr. Norman. So we have another late arrival online. We'll go ahead and take that one as well. AVH, please, let's take it, and then we won't take anybody else.
Thank you, Chair. Queuing up the caller. Caller, sorry for the confusion. Please press star 6 to unmute. Please proceed.
Good afternoon, Chair Taylor and members of this committee. My name is Galdino Griego, and I'm a special education teacher at Desert Pines High School, as well as a proud member of CCEA. I'm calling to ask you to support Senate Bill 368. In my 8 years as a special education educator, I've observed firsthand the importance of consistent, qualified staffing in ensuring student success. Unfortunately, current Nevada school district policies allow unlicensed teachers to lead special education classrooms. In our co-taught classrooms, we have special education staff. These are teachers, paraprofessionals, aides, who are supposed to provide services in general education classrooms so that our students have access to the least restrictive environment. These teachers are being reassigned to cover general education classrooms as substitutes. These practices disrupt essential services, hinder student progress, and compromise classroom safety. The opposite is also true. Sometimes we have general education teachers. These are teachers who could be a person brand new to teaching, substituting in special education self-contained classrooms. When that happens, it is often the paraprofessional having to manage an entire classroom because the general education teacher is facing new challenges that are just not seen in the general education class. Senate Bill 368 addresses these critical issues directly. It ensures that only licensed special education teachers are assigned to special education classrooms and protects specialized staff from being reassigned inappropriately. Additionally, the bill sets practical maximum class sizes for self-contained special education courses, ensuring each student receives the individualized attention and support necessary for their success. Senator Rogich's amendments further reinforce these vital protections. I strongly urge you to vote yes on SB 368. Your support will significantly enhance Nevada's educational environment, benefiting both students and educators. Thank you very much for your thoughtful consideration.
Please, before you go, will you mind spelling your name for us? We didn't get it.
Oh, sorry. Yeah, Galdino Griego, Galdino Griego.
Thank you so much, and thank you for your work in the special ed classroom. We really appreciate that. Okay, looks like that's it for support. Anyone here to testify in opposition? In opposition here in Carson City or in Las Vegas? Anyone to testify in opposition to Senate Bill 368? Okay, seeing none. AVH, is there a caller in opposition?
Chair, we have no additional callers on the line at this time.
Thank you so much. And now we'll take neutral testimony. Neutral testimony for Senate Bill 368 here in Carson City. If there's anyone in Las Vegas to testify neutral, please come forward at this time. Gentlemen, go ahead when you're ready.
Good afternoon, Alexander Marks of the Nevada State Education Association. We're speaking in neutral due to our profound concern over the potential consequence of dismantling the U.S. Department of Education, a move that would severely jeopardize our students' access to a quality education. The current administration is taking a wrecking ball to public education, and if they enact their plans, it will have catastrophic impacts on our students, educators, and families. There's a line from Reagan that often gets repeated in political service, which for the record I hate, about the 9 scariest words in the English language, but I can't help but think about it today. I'm from the government and I'm here to help. It was meant as a punchline, but here's the truth. When it comes to the Department of Education, they are here to help and there's no need to be scared. Today's presentation makes clear the federal government plays a critical role in ensuring students with specific needs are protected, fed, adequately supported. With Elon, Trump, and McMahon plotting to eliminate the Department of Education, primarily for tax breaks, here's what Nevada's facing. IDA cuts, $104 million, Title I, $161 million, Pell Grants, $200 million, CTE, $12 million. These funds are not luxuries, they are lifelines, and losing these programs would not only threaten educational equity, but break our promise to provide every child with a fair chance to succeed. Our state cannot afford to absorb these cuts, and we know that we're $4,000 behind the national average. And while the governor's proposing an increase of just $2, that fails to meet the moment. So when federal funding falls short, the burden will shift to the states, and our budgets are already stretched thin. Dismantling the Department of Education isn't just bad policy, it's a direct threat to the quality and accessibility of public education in Nevada. Families across Nevada support public schools because they understand students need more opportunities, more resources, and greater protections, not less. We agree IDA is important, and we invite everyone to join the NSCA and the National Education Association, the largest labor union in the country, in protesting these federal cuts. Thank you.
Thank you, Mr. Marks. Please go ahead.
Thank you, Chair. I am Brian Wallace, a teacher and the Vice President of the Nevada State Education Association. Nevada State Education Association has been the voice of educators and education support professionals for 125 years and in 17 counties, and we are neutral on this bill. We can neither support or oppose this bill because it is outrageous that this bill is before this committee due to the recklessness of the Trump and Lombardo administrations. My school district, the Carson City School District, receives approximately $11.5 million from the Department of Education through NDE also. These funds support our students, our educators, and our educational support staff positions, our Title I schools, our career and technical education programs, and especially IDEA. To think that a skeleton form or a state-level form of IDEA is needed is unimaginable. To think that this funding could be in jeopardy is unfathomable. These are students, my colleagues' students, and our Nevada students that have amazing potential but need extra supports. Extra supports that they may stand to lose because of both administrations. Gutting federal departments, shifting the workload, and attempting to tell educators and education support professionals that everything will be fine is a lie. Everything will not be fine. Those of us in education already know what it means when we are short on personnel and short on funding. It means it is more and more difficult to do a job that is already difficult. Educating the students of Nevada means everything to me and my colleagues. This is not the worry that we should be shouldering right now. Thank you.
Thank you, Mr. Wallace. Seeing no one else here in Carson City and no one in Las Vegas, AVH will go to the phone lines. Anyone neutral?
Chair, we have had no additional callers at this time.
Okay, thank you so much. That's it for testimony. Senator, would you like to have any closing comments?
Thank you, Chair. Let's just put politics to the side. And Lori Rogish, for the record. I just want to put politics to the side. And I think we should all work together to make sure that we're protecting our children, regardless of what is happening on a federal level. And so thank you for your consideration and time regarding this bill. Thank you.
Thank you, Senator Rogich. Okay, and now we're down to the last item on our agenda, and it is public comment. If you would like to make public comment today, and you're here in Carson City, come forward. If you're in Las Vegas, please come forward at this time. If you'd like to call in, that number is 888-475-4499. The meeting ID is 8972-3472-573. We don't have anyone in person, so AVH, do we have a caller?
Thank you, Chair. To provide public comment, please press star 9 now to take your place in the queue. Chair, there are no public comment callers at this time.
Thank you so much, AVH. All right, committee, thank you so much for your time and work today. We will convene on Friday. We'll make it call of the chair so we can do it as early in the day as possible if we do not have floor, which I don't know that yet, but we have bills we have to get through. So we are adjourned.